Please go ahead, sir. We are live now.
Okay, thank you, Anup. Thank you so much, sir, for this opportunity. I am heading IPR department in ASSOCHAM, also having a few more responsibilities. Definitely, this is the first opportunity, but certainly we will take this advantage and we will continue our engagement for different activities, specifically on IP front. IP Bootcamp we have initiated recently under with the broad objective to promote IPR awareness among students and also provide hand-holding services to the innovator. This is the one part where we are engaging with the universities to have awareness kind of sessions. But second part is that we are also supposed to interact individual startups, MSMEs, or individual innovators from the university and academia to guide them to how we can provide hand holding to take that innovation into the filing part, or it is not restricted to only with the innovations, but it can be for trademark, it can be for copyright, it can be for others. With this idea, we have initiated this, and of course, we have one joint program on L2 Pro. Bhavnaji and others will speak on that L2 Pro program, where the government is giving certificate for appearing in different level of examinations. I won't take too much time. Thank you so much for giving this opportunity. I welcome ASSOCHAM everyone for this webinar and hope this webinar will be fruitful. Thank you so much, sir. Over to you.
Thank you so much, sir, for your kind words. Now I would like to introduce our next speaker. Dr. Bansal. Dr. Bansal is working as a joint director at Baba Farid University of Health Sciences. He has a work experience of more than 25 years at various positions, including 7 years as joint director in the present position. He has been serving as a nominated member screening committee of the Cancer Consortium R&D program, Department of Biotechnology, Ministry of Science and Technology, Government of India, New Delhi. He is the chairman, secretary in 5 institutional ethics committees registered with DCGI and is the chairman, member of board of studies at number of universities. We welcome you, sir, to the session, and I would like to kindly ask you to take over the session.
Thank you, Kirti ji. Thank you very much. Very good morning to all of you. Honorable Professor Raj Bahadur, Vice Chancellor of our university, dynamic leader in healthcare, now renowned spine surgeon, and the state awardee as in frontline COVID warrior. Our worthy registrar, Dr. Nirmal Aushpashan, Mr. Nahid from ASSOCHAM, all my eminent friend speakers, Bhavna Mittal ji and students, and my dear friends. A very good morning to all of you. I, on behalf of university and on my own behalf, I welcome you all in this ASSOCHAM IP Bootcamp Masterclass with Baba Farid University of Health Sciences. At the outset, I would like to thank ASSOCHAM for selecting my organization as a platform for disseminating the IPR activities of the organization. Let me give a brief introduction to all of you. Baba Farid University of Health Sciences, it is a state government health sciences university. We are regulating more than 150 medical education institutions for best medical education and research. We are having all the medical and dental colleges, nursing colleges, and physiotherapy colleges under one umbrella, that is Baba Farid University of Health Sciences. I would also like to introduce ASSOCHAM, which is our partner today for today's activity. Let all of you know that ASSOCHAM is a very big organization, and it is working for the cause of economic development in a vast area in India. And also they're carrying out activities abroad. Today we have joined hands with ASSOCHAM for this noble cause of putting awareness among the medical students, which is a very rare area. Let me share with you that most of the medical students, they are not aware of what is IPR. So I just want to tell you in 3 words that intellectual property right is, there is one creator, there is one product, that is creation, and then for that creation there is protection. So IPR is basically, it enlightens you, it empowers you to protect your intellectual property. You know, if you are having a 5 rupee coin in your pocket, you would check it 10 times that whether it is not stolen by somebody. Similarly, we are not aware of the intellectual property, how costly, how priceless it is. It is very, very costly. It is very worth that we should protect it. So intellectual property is your own property, and the intellectual property rights, they empower you to protect those rights which are yours. So for all these medical students, I should say that, let us say if you are having, suppose you are creating some notes, you are creating a book chapter, you are creating something at your own for your convenience at a short term time, you want to revise everything as in medical education, postgraduate programs. So that is your own creation. If you create your short notes and if you put in copyright, if you want to protect those notes from others to use, or they should be able to use with your permission, that is basically how we want to protect our intellectual property rights. People think that, actually most of the people, they're not aware. Medical field is a bit different type of field in which IPR application is not much in use that way. Let me tell all the participants that intellectual property rights starts from the beginning. Whenever you get up from your bed, you take coffee, you start your life, brush, toothpaste, everything. You wear any clothes, you buy your car, you travel in that car, you use your laptop, everything which is being used by you right from the beginning, in the morning when you wake up and till you sleep, it is having IPR connection. So you people have to think it in that way, that intellectual property right, the brand value which you are using, the brands whichever you are using, this is only because of intellectual property rights. So we should be aware of that. And why should we protect that intellectual property? Because intellectual property is something which will make you rich. Not only that, money wise, it will give you recognition, worldwide recognition, state-wise recognition, and it will increase your the work which you are carrying out. If you create something, somebody else may create something better following your creation. So we need to in fact take care of that. We need to protect that. Most of the processes, most of the products in the medical science, they are non-patentable. However, with the growing Indian economy, with the new policies launched by Government of India, just like Startup India, Make in India, 100% foreign direct investments, and so on, the startup startup filing of the IPRs is increasing because of the changing policies of the government of India, there is a sharp increase in the filing of the IPRs. Let me tell you that India is the largest ecosystem, startup ecosystem, third largest startup ecosystem. So we are in a very strong game right now. Our country is in a very strong game. If we start right now, we can go up to anything. Let me share one thing more. Last year, there were 15 million patents filed by China only, and we are ranking 6th. We are around about 70,000 somewhere. So we should not be lacking behind that. About 700 patent applications have been filed in India, and out of that, 34 have been granted. Similarly, diagnostic field also, which is non-patentable otherwise, they have a number of organizations, they have filed 450 applications, and we have been granted about 38 applications out of that. So number of players are jumping into biomedical engineering sector. Johnson Johnson, Medtronic, Siemens, Dexter International Company, they are putting up number of applications which is in hundreds. So we need to take care of that we should associate our work with such type of organizations which are making your work utilizable. And major work is going on for pharmacy and physiotherapy people also. Pharmacy people, they can look after drug development. There is an orange book database which can guide you about which drug has been already patented, and which drug has been removed from that patent. I am pleased to share with you all that our university is running 2 postgraduate programs, MSc Herbal Drug Technology and MSc Clinical Research. In that part, we are already having 1 full subject of intellectual property rights in our university. So out of 7 subjects of these courses, we are having 1 full subject of intellectual property rights for making the people aware of their research work. Secondly, we are also having a significant part of intellectual property rights syllabus in our PhD program. Right now also our PhD program coursework is going on, and we are making all the PhD coursework people to write the exam and qualify that for intellectual property rights also. I am also happy to tell you all that we had set up an IPR cell in 2010 with the help of Punjab State Council for Science and Technology in our university. Of course, the people are not very much aware of these things. That's why we are here to make the people aware that we should be going up. We have organized more than 10 workshops for intellectual property right awareness. And let me tell all the young friends that we should not be gone with the myths. People think that patent is something very big. We cannot do it. So it is not like that. Let me tell you that patent has been awarded for safety pin. Patent has been awarded for even a needle of the sewing machine. Then people think that I am too small. I am only 15 years. I am only 20 years. I cannot file a patent. I am not competent to that. So let me tell you all that the girl in Texas, she was just 4 years old when she got the patent. So time is important. Time is important. If you file your patent today, then you could be the premier. I would like to share a small story of Graham Bell, who filed the patent for phone. All of us, we are using phone today. The Graham Bell is the holder of that patent, and you know, few hours later, there was one lady who filed the patent for same phone, but she could not get because she was lacking behind for the 5 hours of the filing. So please pick up your papers, please pick up your good work and file it immediately for patent. If you are lacking some awareness, please contact us. We will be happy to share whatever we have with you. ASSOCHAM, it has taken up a very good step. They have designed a program L2 Pro, which you people will download today. It is L2 Pro means learn to protect. How you should protect your intellectual property. So you can go through that program. You can download those things, and they will be organizing a test also, basic test, and you can qualify that. After reading that material, you can qualify that and get a certificate for that also. So I would like to request all of you to register for this program and to be serious about filing the patents and looking after your intellectual property rights. I'm thankful to ASSOCHAM for their cooperation. I'm thankful to Bhavna ji. I'm thankful to Nahid ji. I'm thankful to all the speakers who have taken time to share their views with all the participants. And at most, I'm thankful to Honorable Vice Chancellor and my Registrar sir, who have taken initiative to take up this subject for creating awareness for the students. I'm once again thankful to all of you for giving me an opportunity to share whatever views I have about this. Thank you very much. Thank you, Kirti ji. Thanks.
Thank you so much, sir, for your kind words. We are very happy to know about the IP activities happening at Baba Farid University of Health Sciences. Now I would like to invite Mr. Vijay Kumar Shivji, the Director, Patlex Business Solutions, a knowledge process outsourcing firm practicing in patents and designs. He has over 16 years of experience in pharma corporates, law firms and consultancies, and has conducted 100 plus IPR awareness programs at universities, colleges, bar associations, incubation centers, custom office, industry chambers, and MSMEs. He is also the IPR lead IPFC ASSOCHAM and the mentor of change with Government of India's Niti Aayog Atal Tinkering Labs. He's also the mentor Startup India, Ministry of Commerce and Industry, Government of India. Now I would like sir to kindly take over.
Thank you. Thank you so much, Kirti, for the warm welcome and introduction. And thank you so much, Baba Farid University of Health Sciences and ASSOCHAM for organizing this particular event today, to have awareness about IP and specifically patents in the medical field, basically. Also, I think I should thank Dr. Parveen Bansal, sir, for giving an insights about what kind of activities are happening at the university, and also giving us an idea about what kind of courses they have, and because that's how we would be in a position to understand where is that applicability of IP in as far as the university is concerned. बंसल सर ने बताते हुए एक बात बहुत अच्छी बोली. They have a course on herbal science, MSc in herbal science, I think, which is one of the unique courses, I would say. And there have been lots of myths or misconceptions about herbal patenting, basically. And because we are into a domain wherein traditional knowledge generally is not patentable, but then herbal products, we would be actually discussing about herbal product patenting. Patenting in medical field, as well as patenting in the dentistry, dental products, as well as lots of anything that is covered under the broader domain of medical sciences, basically. And as he mentioned already, lots of activities are already going on internally at the university, and with the support of government, as well as with lots of initiatives by institutions or universities, there has been a lot of awareness. But awareness is one thing. The second thing, most important thing, when we conduct these kind of programs, is also how we can actually implement these at the university level or the institution level. That's when we get actual output from these programs as such. And I'm pretty confident, like, based on the different activities that the university has been conducting out, and based on today's session as well, we would have some fruitful inventions coming from the university as well as the doctors. I'm also privileged, I think, I must say here, because we are into pandemic, and we must congratulate the medical doctors and the entire faculties or the participants of this particular program for taking out time for this session, because you guys are doing a great job during last 2 years, and like, it's been kind of a crazy schedule for every month. But again, innovation is something which is the keyword, and especially post pandemic, we must innovate, then only we would be in a position to survive as. And with this, I would like to start with my presentation. Kirti, can you allow me to share my screen, please?
Sure, sir.
Great. To start with, I think we also have Dr. Ramani from Lexorbis, who would be taking the session on the similar topic, actually, like, but what I'm going to focus more on the first part, that within the time limit that has been provided to me, is patenting specifically for medical institution. To be honest, being coming from life sciences, pharma background, working for long with pharma, but then when I started practicing since last 4.5 years, that point of time, our focus has always been life sciences industry, and we have been already working with medical colleges, medical universities, and few doctors with respect to their inventions, basically getting protected through patents as such. And when we think of intellectual property rights, Dr. Bansal actually mentioned about the we are not actually aware, in most of the cases, the doctors, like, what is IPR, basically what we call as intellectual property rights. And as he mentioned, if we have a coin as well with us, it's basically something which has got some value, property, basically. And that's when we think of it like, ki hai mere paas hai, ek hi kho gaya, has someone stolen it, basically, like, something similar. What we have is a different kind of property, what we call as a intellectual property. Let me put it in a very simple context. Now, many of us have got iPhone, actually, and when we say I have got an iPhone, it has got some value associated with it. That iPhone is actually a property. It has got some value associated. We can see that it's a tangible asset, basically. But if I tell you, how are you going to prove that you own that iPhone? And that point of time, when we purchase an iPhone, what receipt, legal receipt that we get, that receipt is actually a legal proof that you own that iPhone. Something similar, what we ask when we speak about intellectual property, the intangible assets, when we have some creativity, some artistic work, or some kind of technology, let it be medical technology, let it be a dental product, or let it be a herbal product, which we have invented, and how are we going to prove that we own it, or we actually have got the legal rights over it? That those rights are provided for by something called as intellectual property rights. So IPR, a wonderful field, basically, as Praveen sir actually mentioned. Actually, he kind of killed my first 2 or 3 slides, because those contents which I was going to speak, he has already spoken. So let me just repeat it. So basically, every product and everything in our life is protected under IP, intellectual property, and the legal rights are provided by something called as intellectual property rights. Now, when we think of technology, art, or creativity, it is not only the doctors, but every stream basically has got creators. Every field actually has got some creators, some scientists, something which is related to creativity basically. And when, if you can see all these pictures, well-known pictures basically, like, we have Sister Shivani, then we have Manish Malhotra, Vinod Dua, we also have a comedian, we also have this wonderful singer Arunita, and we have one of my idols, MS Dhoni as well. All these people their own sphere basically. They are actually creative. They have got some intellectual creativity, and that creativity, if now one thing is having that creativity, second thing is that creativity actually getting you some profit out of it, or is it actually a what you call, is there a business coming out of it? Absolutely yes. When we have an anchor, when we have a comedian, we have a singer, when we have a fashion designer, when we have a speaker, public speaker, basically we have a cricketer, that point of time, those their creativities are earning them some kind of money as well. And that's the, when there is a value associated with your creativity, one of the most important thing there is that we need to protect it legally, otherwise others would copy it. And how does it actually happen? Since we have got so many creativities, types of creativities, we have some, so we cannot just compare one type of creativity with other kind of creativity. Can we say that Manish Malhotra is better than Vinod Dua? No, they are in different spheres basically. And when we speak about intellectual property rights, that point of time, we have got different creativities, and there are different types of intellectual property rights which are applicable for different types of creativities. And each type of intellectual property right serves only few industries, as in what is applicable for a medical industry may not be applicable to music industry, or what is applicable let's say into the agriculture sector may not be applicable in the medical industry basically. So we have different types of intellectual property rights because we cannot compare the creativity. So we have different laws. Our focus for today would be more on patent, because that is one of those fields which has been very crucial as far as medical industry is concerned. Now, when we think of intellectual property rights, like, generally, as sir mentioned, we have patents, we have copyright, we have trademark. Also, there is something called geographical indication, industrial design, and plant breeders right. So based on the kind of IP protection, like, there are different industries. So what IP basically does, conceptually, intellectual property rights provide you monopolies over your invention, legal rights for your invention, because a scientist working in a lab or a researcher is putting a lot of effort, 5 to 6, 7 years to come up with a great product, let's say. And those products, if it has got some commercial value, it may also happen that all your research is wasted if it is not protected, because very next day someone else may try to have a copy of that product and launch that product. So it's just not, the intent of intellectual property rights is not to create monopolies, rather it is to promote the innovation, so that like, we come up with newer products, newer technologies, newer innovations basically. And those, so based on this fundamental concept of promoting innovation, we have these monopoly rights called intellectual property rights. Now, when we think of different types of intellectual property rights, the first type of IP, and that's most important for any research based industry. Why I'm saying research based industries, because as I said, copyrights may be actually applicable in artistic work or artistic creations or literature, music, and all. Maybe trademark for your logos, brands, and other products. But patent is something which is based on the research based industries or the research related inventions. And when we say this, we have different industries. We have biotechnology, we have the pharmaceuticals, the software industry, automobile industry, and so on. Actually, whatever new invention you come up with, that can be basically protected under patent. As Dr. Bansal rightly pointed out, actually, getting a patent is actually not something that difficult nowadays. And I think we are actually having the participants who are well educated. So we recently, last year we filed a patent for someone who is 60-year-old, but he's someone who is kind of, I would say, just sixth standard pass. Innovation, innovation is something. It is something which is not, I would say, gender centric, which is not age centric, which is not based on your financial conditions. Innovation can happen anywhere basically, and so for us it is very important to understand what is that, what do you mean by actually patent, how does it get granted, as well as how can we actually approach, or what are those different types of invention in your industry. When we are working in medical field, we are working, let's say, broadly speaking, we are coming up with medical devices, diagnostic methods, new product combinations, new products, basically pharma products, or as sir rightly pointed out, the herbal products as well. And from the dental side, we are coming up with dental patches, dental implants. We are coming up with dental products as well, gel products, herbal products as well. Now, in these fields, where is that application of patents basically? Where do we get these patents granted? We are going to see this through some live examples, but before that, I want to let you know one a basic concept. When we think of patents, there are certain criteria which we need to satisfy, then only we get a patent. And the very first criteria, as the name suggests, is novelty, newness. कुछ तो नया होना चाहिए, and then only we would be in a position to get our invention granted or patent granted. Now when we think of novelty, the it is essential that that novelty is absolute novelty, that is global novelty. Your product need to be globally new. It, you get the rights locally, but for example, the product which you have developed in your lab, if it is known in some other language, some other countries, let it be Chinese, let it be Marathi in Maharashtra here, or let it be Korean, any language, if it is available, the novelty is killed for that invention. There is no novelty available for that invention. Now, novelty is the first important criteria, and this is the one thing everyone knows. कुछ नया है तो मुझे patent मिलेगा. But then the secondary criteria is non-obviousness, or what we also call as an inventive step. Now, when we speak about inventive step, it is that one criteria based on which most of the patents actually get rejected. Most of the patents actually get rejected based on the non-obviousness or inventive step criteria as such. Now, because we don't understand what does it mean by non-obviousness or inventive step. Basically, when we think of non-obviousness, it is the predictability or unpredictability of the art. Any student who is actually doing his research that point of time, what we do is during the literature survey, we try to identify whether our invention is new or not, or at that point of time, many a times we get inspired by one article. This is most of the times, when we do research, this is what happens. We get inspired by a research article or a paper or a patent. We try to replace at least one of those parameters which are available in that paper, and then we try to come up with a new product. That new product may be something which is, as I said, it's new means it's novel basically, but it may be obvious as well. It may be predictable to come up with one particular, based on the prior art. Now, let me put it in a very simple context, let us say, to understand what is non-obviousness per se. We have a drug, and most of us know these two drugs basically. One is a omeprazole and second is a pantoprazole. Okay, presume that omeprazole is already available in the market as a delayed release, or what we call DR tablet, okay, wherein it gets the release gets beyond the stomach, basically, like, you know, in stomach it is protected, and beyond that you actually get the release for that. Now what happens, omeprazole is known as an entry coated tablet or a product already available in the market. Let us say you are working on pantoprazole, which is a new drug. Let us for the time being presume that pantoprazole is a new drug, and you are preparing a delayed release dosage form for that. That point of time, pantoprazole is never tried for delayed release dosage form. Pantoprazole delayed release is novel for sure. But if omeprazole is available as a delayed release or dosage form, it is pretty obvious that pantoprazole can also be delivered as a delayed release tablet dosage form. Why so? Because both these drugs, omeprazole and pantoprazole, are proton pump inhibitor. They are acting in a similar way. So when we think of novelty, it is same, exactly same. इन्वेंटिव स्टेप या नॉन ऑब्वियसनेस जब हम बोलते हैं, दैट पॉइंट ऑफ टाइम इट इज सिमिलर, एंड वी नो द डिफरेंस बिटवीन अ सेम एंड अ सिमिलर, right? So that similarity, that predictability of the art, and this is secondary criteria. Most of the researchers, when they do their thesis, they do literature survey, most of the times we get that the novelty criteria is satisfied. But since we are not aware of the non-obviousness or inventive step, people neglect this, and most of the patents get rejected based on this criteria. We have statistics actually, irrespective of the industry, most of the patents get rejected based on inventive step or non-obviousness. At times it is very difficult to prove the non-obviousness or inventive step based on the data that is generated. So it is very essential that we also understand this secondary criteria as a researcher. The third criteria, which is industrial applicability, is something which is actually satisfied for all the pharma or medical related products, basically. So when I say this industrial applicability or utility, it has a meaning that the product has either to be produced by the industry or for the industry. इंडस्ट्री ने बनाया है या इंडस्ट्री के लिए बनाया गया है. If you satisfy all these criteria, for sure you are getting a patent granted as such. But these are the criteria which are like, you know, I would say common criteria if you go to any of the countries. Beyond that, what we also need to understand, there are some specific criteria in India which don't allow certain patents. We'll see that, but I want to actually remove all those myths about patenting first, and then we'll move ahead to the now. Patent filing, I have so during all these sessions I got lots of questions which are like kind of myths. I have put it in here, very fundamental basic understanding of patent concept as well. When should I file my patent application? If you are, to be honest, you don't need to wait for your research to be completed to file your patent application. Patent system allows you, the moment you have an idea in your mind, eventually we are speaking about intellectual property, creativity. आपके दिमाग में कोई भी idea, when you think that okay, based on the drugs that are already being tried, let's say dexamethasone, remdesivir, are being tried for COVID-19 treatment. Can I try this particular drug for COVID-19? I think it's logical. You got that idea, you can file a patent for that. You have some time, within 1 year you can actually generate that data and file the complete application as such. So the moment you have an idea, you can go for it. You don't need to wait till the end of actually, like, you know, the filing of the the research completion as such. Why should I file patent application? I think I don't need to discuss this in detail. Dr. Bansal has already covered this part. Beyond that, as an academician, or if you're working with a university at that point of time, it would add a lot of value to you as an individual if you have some patents in your name. What data do I need to file a patent application? Basically, the data that is required for patent application depends on what kind of protection you are securing. There is no standard format or standard thing actually that like, we need this data, we need clinical data. At times you don't need clinical data. Even your preclinical data is more than sufficient to file, even getting a patent granted. No one is going to ask you whether you have conducted the clinical data or not. Even preclinical data, animal studies, forget about animal studies, in few cases even in vitro data is more than sufficient. The cell line data is also sufficient to file a patent. Like, that is allowed. Shall I take help of a patent agent for filing? Now, this is one crucial question most of the people ask. See, the answer to this is you are a technical expert. You understand the technology very well, but then patent is a techno-legal document. That's where you would need a help of a patent agent basically for the filing of a patent. Because a patent agent, like I come from pharmaceutical life sciences background basically, I understand an invention in the medical field, dental field, or herbal. Herbal has been our forte, like we have been working for the herbal invention since long actually, like, and so I understand the technology. I also understand a bit of patent, I would say, as a patent agent, and that's the reason we recommend to go take a help of patent agent, but it is not mandatory legally. You on your own can also file your patent application. It is not mandatory to take a help of a patent agent. First, most important thing, can I publish my research paper before or after patent filing? Before patent filing, it is not recommended, although there are certain exceptions, but we don't recommend it to anyone to do that. So for example, if you really want to protect your invention, don't publish, don't present in the conference. File first. आज file कर दिया, कल आप publish कीजिए. There is no concern for that. आज अगर file कर दिए होते और कल publish कर. After patent filing, you can do that, but before patent filing, it is never recommended. Although there is a grace period, but we don't recommend that because at times it gets really tricky actually. Can I commercialize my invention after patent filing? First thing, there is patent rights are negative rights. You don't have any connection between commercialization of a product and patent. If you get a patent for a new drug, still you have to conduct the clinical trials. If you get a patent, you cannot launch your product, but you can block others from using that molecule or product. That's how the patent system works. So commercialization is something you cannot do. You need to go through the regulatory pathway. As I said, in case of drugs, the FDA, or in case of telecom products, the Telecom Regulatory Authority of India. So you need to go through that routine process of commercialization. But without your permission, no one else would be in a position to do that. How much is the cost for patent filing? I think all the fees are available with the patent office website, and ASSOCHAM IPFC is providing these services for patent filing and all. You can get in touch with the ASSOCHAM IPFC team to get the quotations for patent filing as such. But then it also depends on what is that value that is coming out of it, and based on that only that cost would depend. Can I file my patent application without telling my guide or institute? A very common question. In fact, one student approached me. She said, sir, I want to file a patent. I've got a good invention, but I don't want name of my guide to be included in that actually. I said, why so? She said, I have some reasons. Of course, she told me the reasons. I can't disclose it here, but can I file a patent application without my institute or guide? Yes, it may be feasible if your institute doesn't have IPR policy in place. As Dr. Bansal mentioned, the university has an IP cell. It must have IPR policy as well in place. If you have IPR policy in place, probably you can't do that, but check it with your organization if you don't have IPR policy. And in fact, what has happened many a times is, like, students approach us through this, and at times they file on their own as well without telling the institute or guide or even patent agent's help. Now, a very common thing I would say, like it happens in India basically. Can someone else file patent application for my invention? एक ही lab में 4 लोग काम कर रहे हैं, and we had this case happened actually. Like, for me, if my invention is actually not protected, I am not filing a patent, someone else can take that and actually file the patent. It has happened, it happens actually. Like, we नॉर्मल लैंग्वेज में हम इसको चोरी बोलते हैं, बट दिस हैपेंस इवन इन इंटेलेक्चुअल प्रॉपर्टी एज सच. So to avoid that scenario, you need to ensure you are filing your invention first before someone else does that. Now, how does a patent system actually work? Patent filing, when does so we have two-tier system as far as patent is concerned. In the first tier, I would say the patent application gets published, and it gets published usually after filing within after 18 months, and in few cases that patent application would be published within few weeks, as well as far as early publication option is available in the so it is only it can be this option can be accessed through some extra fees that need to be paid actually to the patent office. So normally 18 months, but it may happen that in one of the cases the application got published in 3 days time. Tuesday file kar diya, Friday publish hua. How much time does it take to get a patent granted? Now, usually it all depends actually, most of the times in medical sciences or pharma we have seen 3 to 4 years is the time, but then there is an expedited examination process as well available, under which, but then you need to remember that there are certain people only or certain criterias wherein you can get your patent granted, let's say within 7 months, 8 months, or within a year as well. Filing a grant within 1 year. In fact, we have a case wherein we filed it in the month of April, and it is already in the grant stage, but then it would get granted only after 6 months. That pre-grant opposition period is expired after that. So in that case, what are those requirements? If you are filing as individuals, and there is one female inventor, then in that case you can go for expedited examination. If you are filing as a university, that may not be allowed. If you are filing it as a startup, so if you are registering yourself as a startup with Government of India, then you are allowed to file for expedited examination. If you file a PCT and you designate India as a searching authority, ISA, at that point of time you can actually go for the expedited examination as such. But otherwise, normally, like I would say, if we file normal process without some extra cost or expedited examination, 3 to 4 years, I think fair enough actually, if you are filing the forms and everything on the time, proper time. Does publication of application assure grant? Not at all. We have two publications, one as an application and one as a grant. Once whatever you file gets published as a published application, and the other thing is once it gets evaluated after that, after grant as well, it gets actually I would say published again. Cost, as I said, you can get in touch with the IPFC team. Can I commercialize the invention after grant? Again, the same answer to this. Commercialization is different. Now, every most of the times I get this question actually, and we read this in newspaper. Many of us are inspired by Funsuk Wangdu, especially after the movie 3 Idiots. Would I be Funsuk Wangdu once patent gets granted? In fact, few days back on LinkedIn, I saw this post. I have got a patent granted. If someone wants to if someone wants, come to me, give me some money and take that patent from me. Let me tell you something. If you are getting a patent, you are not going to be Funsuk Wangdu. No one is going to come to you, to your place, giving you $1 or $1 billion rupees or US dollars and say that we need your invention. It is not going to happen. Eventually, it is not the patent that is going to get sold in the market. It would be the product. It would be the product which need to be sold. So when Chatur Ramlingam came to meet Funsuk Wangdu for taking that license, there was some product which Chatur Ramlingam wanted to commercialize, but the rights are with Funsuk Wangdu. Another important thing, always remember that it is not about whether you have a patent or not. It is also important what is that protection available. Is it really protecting the competition from your product? If you have that kind of product, really good product, come to IPFC ASSOCHAM, we would get you best of the partners for commercialization of that product. That is possible actually. We also have other agencies in India as well, which are actually involved into IPR commercialization as such. So, but again, depends on what is that protection available and what is that product. आपके product का market में there would so we speak about IP valuation, patent valuation also, like, you know, there are some agencies who do, but eventually when we do that point of time, it is more about what is that product, what is its value basically, and is there sufficient protection for that product in the patent. Then the answer is probably that you may get some money like Funso Kwangdo basically. Design and patent at this point of time, I won't discuss much because I want to take the medical sciences part, to be honest. Now, when we know that novelty, non-obviousness, and industrial applicability are the clauses for getting a patent granted. Beyond that, in India, we have specific clauses which don't allow us to have certain inventions granted. Like, for example, mere admixtures or the combinations, two herbal products combined with each other, two herbs for the treatment of arthritis, दो अलग-अलग herb का mixture बनाया, not patentable. Method of treatment, second medical use, the diagnostic methods, therapeutic methods and all, they are not patentable per se. And traditional knowledge is not patentable, but this but helps you to get the patent granted basically. Mere admixtures are not patentable, but the combinations, if they are showing synergy, for sure they are patentable. Now, what do you mean by synergy? So, for example, we have got these two anti-diabetic drugs. One is metformin, the other one is sitagliptin. Let us say metformin is showing 10% HBAC reduction. It is one of the clinical parameters basically, and let us say sitagliptin is showing 25% HBAC reduction. Now, if you combine these two, ideally you should get 35% HBAC reduction in the clinical parameters. But if you combine these two, instead of 35, if you get 50% HBAC reduction, that's where we say synergy is there. In case of combination, हमारी simple language में जैसे हम एक और एक 11 बोलते हैं ना, वो अगर possible है, in that case those combinations are patentable because they are not mere admixture. When two things got together with each other, there was a synergy associated with it, and that synergy can be patented. As far as traditional knowledge, herbal products are concerned, the most important thing to understand is if you take a herb, let us think about a normal example like curcuma longa, that is haldi basically. If you want to protect haldi as a patent, if you want to have a patent, definitely it's not patentable under traditional knowledge or novelty. But let me tell you two problems of haldi. One is its solubility, and the second one is the staining effect. Skin pe ya clothes pe staining reh jata hai. But if you come up with a end product, which makes haldi soluble, so we call it a nanotech, in maybe through nanotechnology or some technology like co-crystallization or solid dispersion. Typically in the pharmaceutical technology we call this. If you prepare a product of haldi which can be actually, I would say, helping you get rid of the solubility problem or the I would say the staining effect, yes, that product can be for sure patented. And how this can be actually, and this is actually, like, you know, possible. We have got so many patents for herbal getting granted actually. Now, what happens is when we prepare a product for herbal, what we recommend usually is, if you have a herb, try to put it into a modern dosage form, and getting a patent for that is pretty much possible. As we have lots of cases. Now, as I said, why do patents get rejected? Because of the major criteria is obviousness, as I already mentioned you, and we have discussed it in detail as well. Now, basically, patenting is something which I would say is an art. Patenting basically is an art to put science in a legal language. Art to put a science in legal language, and that's what typically a patent agent does basically. And I'll tell you it with a very wonderful example, and that's the reason I tell you get a help of some patent agent who can help you, who first of all get a help of a patent agent who understands your technology first. Because if an agent can understand your technology, then only he or she would be in a position to put it in a proper format so that you get a patent granted. I'll tell you how patent is actually an art to put a science in a legal manner with this one particular example. And I must say this is one example which everyone knows basically. And if you let me read it out for you. It's an edible product comprising a spherical enclosure which is crusty. There is a spherical enclosure which is a crusty, and there is a hole into that, the hole providing access to the volume internally. That hole, through that hole, some volume, liquid volume can be put, and that liquid volume contains a fluid mixture of mint, spice, and water, which is disposed within the volume. A sauce comprising tamarind and a sweetener, the sauce disposed within that volume, and a portion of boiled potato, boiled chickpeas, or boiled mung bean. Every one of you knows this. Every one of us actually love this product. This is the actual claim, hypothetical claim basically created for a product what we call in Maharashtra as pani puri, and actually in North what we call it as a golgappa. Now look at this, एक edible product है जिसमें spherical है, एक hole है, and a fluid mint है, उसमें spice है, water है, sauce है, sweetener है, potato है, and chickpeas and mung beans है. Now this is how typically a invention is put, or a agent who understands the technology, he can put your invention in a proper format, what we call as a claim. Now this is a hypothetical example, but practically speaking, when we think of different types of inventions, let us think of herbal patenting. As I said, there are lots of myths about herbal patenting basically. In case of herbal patenting, we have lots of examples wherein patents have been granted. Look at this example now, a topical herbal formulation for the treatment of arthritis comprising leaf extract of A and other plant extract. Other plant extract includes ABC. And now, what is the difference? How is it actually not a traditional knowledge? The traditional knowledge would tell you using these for arthritis treatment, but in what concentration, in what dosage form? Look at the dosage form, the topical, the semi-solid dosage form, what concentration they are actually getting in specific concentration. And that's where this product can get actually, this is a live example. You have seen the patent number as well, IN 317619. So what is the product? Basically the end product is an oil product, wherein the formulation is an oil for topical application. Topically apply करने के लिए oil बनाया है, which includes these 4-5 things basically. And why it has already overcome section 3? Because it has shown some synergistic effect as well. Another example, a herbal biscuit. If you see here, like maize, wheat, soybean, dalia. If you ask me what is new in this, basically we know the biscuit products contains these ingredients basically, but a composition with specific I would say quantities is something which has been patented. We have got weight ratios as well. So for example, 1:10:1:5:1:. In this particular ratio, I am actually having a herbal cola, which is soft drink composition of herbal cola. Just we have Coke and Pepsi, something similar. Herbal drink ready to serve, or the soft drink basically, that is also protected. We have, of course, lot of example. If you convert into a modern dosage form, like in this case 2 herbs have been actually formulated into a tablet, which includes carbopol, microcrystalline cellulose, blah, 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 lots of other excipients, it can get patented for sure. Herbal products, as I said, are definitely patentable, provided that these products are actually put it in proper format as such. Herbal products, herbs themselves cannot be protected. Now, let us move on to the next kind category, which would be very crucial, especially for the university or the participants here. Medical devices. If you're working on any medical device, any implant is basically, that is something which can be definitely patented. Look at this example, which is a medical device, basically any ion-based alloy absorbent implantable medical device, basically. So it is what it contains is alloy matrix, basically, and there are lots of ingredients. Of course, this is just a first part of the claim that I have actually included here, but medical devices for sure are patentable, provided they satisfy the criteria of novelty, non-obviousness, and definitely industrial utility. Okay, medical devices are definitely patentable. Look at this, another medical device. Now, if we have people from the orthopedics side, actually, if you're coming up with some devices or some kind of products which are very much useful there, they can definitely be protected as implants as well. Implants are very common in the orthopedics, actually, and many other departments. These can definitely be patented. Medical devices all are allowed actually to be patented as such, provided they are satisfying those the golden criteria of novelty, non-obviousness, and industrial applicability. The next thing, some examples I have put in here. Packaging for a medical product, yes. Container, yes. Medical liquid administration, these are some examples. I have just taken the titles because of lack of, actually, I would say, time. I just wanted to let you know what kind of inventions are patented basically in the medical field, what the doctors are actually doing, or what our clients are also doing. Then we have dual coating on implants. Medical implant is already available. You are coating it with something else, and that coating is providing you wonderful results. That point of time, that also can be patented. Medical diagnostic slide with sensor and IoT, Internet of Device device, that is also protected. We have drug delivery technologies, targeted drug delivery, anti-cancer, the drug delivery to brain, wherein lot of technology is involved. That point of time, all these technologies are definitely patentable. And if you're working on with some pharma in collaboration with pharma company, or if you're working on some new products, basically, definitely these products are patentable. What we call as a new formulation or new dosage form, even new dosing regimen in few cases. So thrice a day available, you make it once a day, once daily dosing regimen, that is also patentable. New drugs, definitely yes. Let's move on to the dental side now. From dental side, what inventions we have got is a dental composite and the process thereof, dental composites, dental care compositions, the external compositions. Many a times you also have this caries, dental caries, and something you need as an agent or a product to remove the caries. For that as well, dental cement compositions. Again, all these inventions, whatever you are doing, if it is new and having some inventive step, non-obviousness, for sure we are going to get it patented as such. Pharmaceutical composition for dental treatment, yes. Polymeric gel matrix, gels, very common. In fact, we recently got a patent granted on in situ gel. So it's a liquid basically. When it goes inside, when it's injected, it becomes a gel basically for the dental treatment as such, because the retention time required in dental products at times is really very higher, especially when you are carrying out some kind of surgery and all, so these are some examples wherein we have got dental inventions as well being protected as such. I'm actually done with my session. I have tried to cover most of the parts which I would say is related to the I would say the medical sciences, and I had been instructed to specifically speak on the horrible patenting side, as well as, like, since we have got dental institutes as well part of this. So, like, thank you so much once again. Thank you so much, Dr. Bansal. Hopefully we are living up to your expectation for this particular session, and hopefully this session would help you understand the criticalities while patenting, and we have a lot of inventions coming from URNS. Thank you so much. Thank you, Kirti, and over to you. I am open for the questions.
Thank you so much, sir. It was a very good session, concise yet very informative. I would like to invite Dr. M.V. Ramani as our next speaker. For that, I would like to introduce ma'am. Dr. Ramani V. Markani has over 17 years of experience in patent preparation and prosecution. She was working as a senior director with Clarivolix Knowledge Process Private Limited. She was mentoring patent engineers and supervising the patent development team in Bangalore to ensure high quality of patent applications. She has a BTech and MTech in chemical engineering from Osmania University, Hyderabad, and also her PhD from IISc Bangalore. She has received her JD and LLM from the Franklin Pierce Law Center, now University of New Hampshire School of Law. Welcome, ma'am. I would request you to kindly take over the session.
Thank you, Kirti. Can I share my screen?
Yes, ma'am.
Can you make me a presenter?
Yes, ma'am. You can now.
Yeah. Can you see it?
Yes,
Can you
ma'am. We
share?
can. Yes,
Yeah.
ma'am.
Right.
Yes, ma'am.
Yeah. Good afternoon. It's already past 12. So good afternoon, everyone. And I thank the organizers for giving me an opportunity to be with the students of the university. And Dr. Bansal, thank you very much. And Vijay Kumarji, you really made my life easier. You put a lot of background, so I don't have to really spend much time on the fundamentals. To have a flow of my talk, I may have to repeat a few. I'm sure it will be not a repetition. It will be more useful for you to hear once again. We hear more and more, we learn more and more. So some may be repetitions, but let's move on. So we know that we have evolved, right? The technology has been evolving. We started with one wheel, then we found two wheels, then we have a car with 4 wheels. Now we have luxury cars. So we are evolving. So humans are putting their intellect to evolve from one stage to the recent stages. Just you remember how was the penicillin detected? He found it on the bread, right? And now we have vaccines for COVID. So just moving. So how do we recognize their hard work? So if I work hard and you come and copy it, take it away from me, I'll not be right. I will not be motivated to do more work. So governments and the systems decided that we have to somehow protect them, give them some protection and some recognitions for their creativity and hard work. Okay. So what is a patent? We already know that patent is Patent is a territorial right that is granted by a government authority for invention in a field of technology. The field of technology could be computer science, pharma, medical, anything, but it has to be an invention. So what will it give you the patent? It will give you a right to prevent others from making, using, distributing, selling, or importing your invention. So they cannot do it any of these things without your permission, provided you are a patentee of a particular product. So invention could be a product, it could be a process, it could be an apparatus, anything. It can be anything. And it gives you protection for 20 years from the date of filing the patent application. Okay. So this is very important. Mr. Vijay Kumar kept on insisting, right? Every minute I heard him saying that these are the conditions for patentability. First condition is novelty. So you should be the first one. Even a small clip in a comic can kill your novelty. So be careful. So someone came up with a wiper on his glasses while driving. It rains and he was driving a two-wheeler and his glasses are getting covered. So he wants to have a small wiper to clean his glasses. The same thing was given in a comic in a very funny way. So that was not novel. So novelty has to be absolute novelty, as he already mentioned. Even a comic or a newspaper cutting published in China, published in Russia, anywhere, it should not be published. That is a novelty step. Inventive step, as he already mentioned, it has to be non-obvious. A person skilled in that. So I'm a chemical engineer, so I may not be able to judge electronic inventions, right? Because I am not a person skilled in electronics. So a person skilled in the art, the minute he sees, oh, it's so obvious, why should I worry about it? For example, there was it is a very important US case law. So there was a metal knob, right? So metals, and it is a knob on the door, and the door is on the outside. So whenever it rains, the metal gets rusted. So someone came up with replacing it with a wood, for example. I'm just giving an other. So what do we know? Like it's very obvious, right? Everyone knows that metals are getting rusted, our wood is not stable. So if someone can combine these together and come up with a wooden knob or metal knob, vice versa, so it's obvious, right? For a person skilled in the art can easily come up to the invention. So that is not patentable because it is very obvious to a person skilled in the art. And the third one is industrial applicability. So as he mentioned already, it has to have some utility, some industrial applicability. So someone in the US, there's a lot of snow on the roads. So someone came up that he wants to run hot pipes under the road such to melt the snow. Is it industrially feasible? How much energy would be required to run the hot water or steam under the snow? Right? The patent was rejected because it's not industrially applicable. Okay. So what are the different types of applications? Basically, now today we are learning a little bit about how do we file in India, how do we file outside the countries, what are the facilities available for a patentee. Okay, so first is provisional application, and we have a non-provisional application. We have something called as convention application. We have patent cooperation treaty application, PCT national phase application, patent of edition, and divisional application. I mean, I will not really dwell. I mean, it may be a little too much for you to absorb, but just understand that what is system is available for all of you if you want to patent. This is a provisional application. Suppose you are a student and you have a conference tomorrow and you have to publish it. But we know that it has to be novel. It can't be published outside unless you protect it first. You're quick. You don't have time much. You don't have much time to worry about to file a patent application. You didn't even complete your research. It's not fully ready. It's not ready to be patented. Just don't worry. Just go and file a provisional application. It just your research paper can be published, can be filed as a provisional application. It doesn't have to have all the formalities. It can be as just it can be your idea. You can be just protect it as a provisional application. So you have 12 months. After filing the provisional application, after getting a patent number, then you have 12 months to file for a non-provisional application, or it is also called as complete specification. So meanwhile, you can disclose, you can publish, you can present your thesis. All these things can be done. But first step is you have to have something in your hand, and that's how we file a provisional application. Many startups approach us, right? They ask us, please file a provisional application. We need the number. And we need the number to approach our investors, right? So you can approach your investors, and also you can write on your product patent pending. So it will basically, the provisional application gives you priority over your invention. It enables the applicant to use patent pending on their product, and it is less expensive, right? It's not really expensive because the important part of a patent application, if you remember, just you have here, Mr. Vijay Kumar showed so many examples, are the claims. Claims are the ones which define the metes and bounds of your invention. So how do you protect your house? You have a compound wall, right? So similarly, your invention is protected by the claims. So for provisional application, we don't have to have claims. For complete application, we need to have proper claims. So for provisional application is comparatively easier and cheaper to file provisional application, and we have 12 months to go for a complete application. Just remember one thing, if you do not file your complete application within 12 months, you will lose your priority. Your provisional application will be abandoned. Provisional application will not be checked by the patent office. It will just lie there. It will just get you a number. But when you write your complete application, you will say that, okay, I filed the application on September 8th, 2021. So you have time up to September 8th, 2022, right? So you can mention your priority number. But if you don't do that before within 8th of 2022, you lose your application. You lose your priority. Okay, convention application. We'll go in little more details little later. Convention application is suppose you are filing in India and you are interested to file in other countries, right? So we have something called as Paris Convention, where we can file application in India. It is not very expensive, and then we can wait for 12 months to enter into the different countries. So which countries I can enter after 12 months? Only those countries which are members of the Paris Convention. Suppose US or most of the countries are members of Paris Convention. So I file in India today, why can't I file right away in US or right away in Europe? US, it's okay, at least English. In Europe, imagine what happens. You have to have translations, right? So it will be so expensive. So at the startups or universities who are really having crunch of funds, they can't afford to file in other countries right away. So they want to breathe in some time. They want to understand the technology. Is the technology really going to be useful in Singapore? Should I protect it in Singapore? Should I go to US? So this time you need, right? Even big industries will take this route, right? Because this gives you 12 months. So convention application is an application filed within 12 months in the convention countries, which are all the members of Paris Convention. We will go a little more detail little later. Okay. Then what happened? We have something else called Patent Cooperation Treaty. So what happens is, convention countries is 12 months. If you really apply your application through PCT, Patent Cooperation Treaty, you will have time to enter each country either 30 months or 31 months, right? So imagine a business or imagine a startup. 30 months is such a good enough time for him to understand which countries he has to enter. So that's how it is called. That's how it is evolved. That is a Patent Cooperation Treaty. So 153 countries are members of Patent Cooperation Treaty. Very few countries like Taiwan, Argentina, these are important countries which are not really members of PCT. So what we do in that case is we have to enter it in the 12 months. Suppose you are an electronics industry and you know that Taiwan is your market. So unfortunately, you have to file in Taiwan within 12 months because Taiwan is not a PCT country. But 153 countries are members of PCT. So you can file in India. You can wait for either 30 months. Some countries have 30 months. Some countries have 31 months. India has 31 months. So you can wait for 30 months to enter into the national phase. That is called national phase. That is, you are going into each national phase. Only one thing you have to remember is PCT is not a granting. It will not grant you any patent application. It will give you a number. And then you have to go to US, you have to go to Europe, you have to go to China after 30 months. And then those laws will apply. We remember the first slide I showed you, patent rights are territorial, right? So each country has their own legal system. So based on that, your patent will be granted. So what is the advantage of PCT? You get an international filing date and you have 30 to 31 months to enter into the different countries. Okay. So one more thing, what happens is in the PCT, I don't want to give you too many technical details. We have something called as international search report. When you apply for a patent application via PCT route, at the end of 18th month, it will be published and you will also get a search report. They search, PCT will search and say, oh, look, your invention is not patentable. Look, your invention is not inventive. So you will get an idea before how is your invention. You didn't do anything, right? You just filed in a PCT application. That's all. You didn't enter any Europe. You didn't incur any translation costs. Nothing you did. You just entered. Then you will get a ISR, that is called International Search Report, which gives you an idea whether your invention is novel, your invention is patentable. Should I go ahead? Should I kill it here itself? It's useless. They found so many prior art. It's not useful for me. So you can stop proceeding into the national phase. So it will help you to save money. So that is the PCT application. We'll go a little more detail about that. Then we have something called divisional application. One, you are getting a monopoly right for one invention. So you cannot have more than one invention in one application, right? So generally what we do, we put 2-3 ideas in one application and try to file application to get one patent and covering many ideas, which is not right. You are getting a monopoly. So the patent office will say, look, your patent application is having more than one invention. Please divide them. and you can have two different applications. That is called a divisional application. We have something else also called as patent of edition. What is that? You already filed application, almost ready. Then use the delta invention. I mean, you have done very little change, not full-fledged change, but it's an improvement over the existing application. So what do? Do we have file one more application, entire application? Not necessary. You have something called in India patent of edition. In the US, we have continuation in part. At CIP, yes. So you can file a patent of edition for the new delta idea. I mean, it should not be a very big idea. It's only the existing idea. To that, you are adding the little bit. Okay. So what is the patent process? How does it start? So first, generally, what we suggest is you do prior art search, you do patentability search. Now, so many tools are there available freely, right? You have all the patent offices are opening their websites, so they're all free. Google Patents is there. So do a prior art search. So you can save some money. So get an idea. What is the thing happening in the world? What's happening in this particular technology field? So you can just look at that, do a prior art search, and then you draft a patent application. You prepare the forms, form 1, form 2, form 3, etc. There are many forms in India, and then file the patent application. Up to you. Up till this is in our hand. Our hand means either your inventor's hand or in the patent attorney hand. That's all. We are done. By filing a patent application, we finished our duty. Now the patent office will take over and they publish the application in 18 months. They'll examine, they'll grant a patent, and patent grant is not end of it. You have to pay the fees. Otherwise, patent will get abandoned. You have to pay the fees for 20 years. Again, they will decide whether to continue the patent for 20 years or you don't want to pay money for it. It's not easy process. It's an expensive process, especially in the other countries. The maintenance fee is extremely expensive. So you have to make a call whether I need my patent to go up to 20 years or I can abandon anytime. If I don't pay, automatically it will get abandoned. Mostly software inventions will not run for 20 years, whereas pharma patents will run up to 20 years. You know that, right? Generic and branded drugs, lot of competition. So generic drugs will be waiting for the patent to get over. The patent term to get over, they'll be waiting. So for pharma, most of the patents will run for 20 years. Okay, how do we file the product? This Mr. Vijay Kumar already told us. We'll just quickly through this. We'll file an application, then we'll publish. After 18 months, the application will be published. Then you can request for an examination. It will be examined. Then examiner will give you something called as office action, or in India it's called first examination report. So you will get a first examination. Examiner will argue. He'll say your invention is not novel. Your invention is not patentable because of it doesn't have inventive step, or it is following under section 3. Section 3. India is the only country which defines which inventions are not patentable. Right, so it can be section 3 rejections can come, and novelty, utility, scope. You didn't define your terms clearly, so anything can come. Then we can prepare a response. So that's where we prepare a response to the first examination report. Then we have one more chance to talk to the examiner, that is called oral hearing. So examiner is still not happy. You convinced, you wrote so much saying that, see, my invention is different from D1, my invention is different from D2. D1, D2 are the cited art. But examiner is not happy. He'll give you one more chance, that is called oral hearing. Nowadays, most of the oral hearings are done by video conferences. So where we explain again and tell him, no, examiner, look, this is how I did. You have an opportunity to talk to the examiner directly on oral hearing. Then if examiner is happy, you will get a grant, and it will be after the application will be published. This is similar thing again, more clearly. Filing, early, different types of publication are there: early publication and regular publication. Regular publication will happen within 18 months, and early publication can happen much earlier. If you are a startup and you are in a hurry, you want to get it out to the public domain, you can request for early publication. Then examination also. Examination, you can file a request for examination after 48 months, but you are in a hurry, pay more money, get expedite examination. Then we'll get an FER, I told you, right? We'll reply to the FER, we'll get an oral hearing, we'll file a written submission to the oral hearing, and we'll get a patent application granted. Right? What are the formalities? I mean, you don't have to really worry. We have every law firm, we have a paralegal who will maintain all these forms. So form 1 is an application for a patent. It generally contains everything. And form 2 is basically your invention, where you either provisional application, all your technical matter will be in the form, submitted in the form of a form 2. And we have form 3. It's very, very important to let the patent office know in which countries you have filed, right? It is In the US, it's called duty of disclosure. Here in India, it's compulsory for us to let the patent office know I filed in China. This is a status. So it is compulsory to let the patent office know in which where did I file the corresponding, not all other applications. Suppose you file in India and the same application you filed in China, that details you have to give to the patent office in the form of Form 3. Then Form 5, declaration of the inventorship by the applicant, right? You have to declare that I am the inventor for this. And then if you are not filing and if you are authorizing any patent attorney, then you have to give a power of authority, right? You are on your behalf, the agent is filing the application. So that is power of attorney. And then post-grant requirements, we have to pay the renewal fee within 3 months, and no need to pay a fee for first, second years free. Then every year you have to pay from third year to 20th year. Extension, if suppose you fail by mistake, you failed to pay the fee, you can have 6 months extension. You can pay, you can request and tell them that by mistake I forgot or something like that. You can pay the fee within 6 months extension. If you don't pay the fees, the patent will get abandoned. Then this is working of patent. It may not be much for the universities, but basically, if you have a patent, it is necessary to file Form 27, where you have to say, yes, I am working on my invention. No, I'm not working. I'm still developing the prototype. Something you have to tell the government. You cannot have a patent application and you cannot patent granted and you cannot sit over it, right? You are not. So why you can't do that? You have a monopoly. You are not practicing. You are not letting others practice. That is not right. So working of patent, you have to. There is a form. We have to. Is basically especially for multinational companies, right? They just get the patent for the sake of getting patent in India and they don't work, right? Especially we had a problem with other pharmaceutical companies. They don't develop the drug in India, but they have a patent here, so they don't allow the generics to use to produce a drug. So in such cases, it will be we have something called as compulsory licensing. It's altogether a different topic, so we will not much about it. But if you are having a granted patent, if you are not working, then government may ask you to give a license to others uncompulsory. That is called compulsory licensing. Okay, so you have to submit a Form 27. Okay, how do we do that? Let's move on to the international filing. We have a direct filing. Direct filing in the sense you file in India today. Today itself you can file in the US. Now no one does that anymore. We have Paris Convention, I already explained, and we have PCT, right? These are the rules. Direct filing is directly filing a separate application in the same day in all the countries or in whichever country you want. So it's a useless method, right? No one does this anymore. Okay, this is the Paris Convention. So we file application locally in India or in any country you are a citizen. Then within 12 months you can enter the different countries. That is the Paris Convention system. India became a member of Paris Convention system in 1998. So we are using this advantage only from 1998. Before we were not members, so we had no choice. We had to file a direct application. Before 1998, if I file in India and I want a patent application in the US, I have to file in the same date. But fortunately, India signed up to the member of this thing in 1998. Okay, I think I have to move faster, I guess. Okay, so PCT we already know. So compared to PCT and convention application, definitely PCT is better. Why PCT is better? In convention application, you'll get 12 months time. In PCT, you will get 30 to 31 months. And you will get the strength of the invention only after filing in case of convention application, whereas in PCT, you can know during the international phase itself with the ISR, right? So comparatively cheaper, and it basically may not be cheaper, but it differs your cost. It will give you some time to spend your money. Right? That is the advantage of PCT. PCT is basically internalization of one single application. You will get time to make your decision. You can defer your cost, and you can also get a patentability assignment. So this is the basic background. So we have a Paris Convention route, we have patent cooperation treaty route. So if you are very sure that you are not wanting to file in many countries, then maybe convention country is cheaper, faster. Suppose you are very sure that you want to file only in US and Europe or in some countries, then maybe you can take the convention country. But you are indecisive of which countries, then we advise you to go to the PCT route. Now let's look at medical device. How are we doing? Right? India is among the top 20 global medical device markets, right? We are in 20th position in the world, and we are in the 4th position in Asia. After first is Japan, China, and South Korea, and then India. The value of medical device is expected to be 5.2 billion US dollars. Around 750 to 800 medical device manufacturers are there with us, and average investment is around 170 to 200 million, and turnover is 450 to 500 million. And there is an expectation that it can grow at 28%, and it will reach $50 billion by the end of 2025. Okay. So what are the preliminary laws, primary laws governing the medical devices? We have Drugs and Cosmetics Act, and we have medical device rules, which are in 2017, they have been enacted. So medical devices come under the definition of drugs. So as such, Indian patent law doesn't define what is a medical device, but under these two laws, these two primary laws which are governing the medical devices, it comes under the definition of a drug. Okay, and both this 1940 Drugs and Cosmetics Act and Medical Device Rule, both combined together, the effect of medical device started from April 1st, 2020. So recently, all medical devices imported into or manufactured in India have to be regulated under the Drugs and Cosmetics Act, right? Very clear about why do I have to be regulated? It is something directly affecting the human being, so it has to be regulated. How do we define medical device? According to our Drugs Act, it is any device including instrument, apparatus, appliance, implant, material, etc., whether used alone or in combination, including a software. For example, CT scanner, right? CT scanner needs a software. So all these things put together is called a medical device. This is the definition of a medical device given in the Drugs and Cosmetics Act. Okay. Now, these are all the regulatory part, right? So then, but people have been realizing that these have to be also protected under intellectual property rights. So this also started emerging as a forefront of the medical devices. Patent applications are increasing in the field of medical devices in India and abroad. Healthcare and medical devices domain, we have the largest number of, this domain is the largest number of applications where Indian inventors are filing in the US. US is the market, right? So we realized, so we are filing more and more applications in the US. Okay, so GE Medical Systems, Philips, and Sanofi, these are the top players in health and medical systems patent filings. Unfortunately, Patent Act as yet doesn't define what is a medical device. Okay. Again, and as I said, when we became a convention country members in 1998, similarly we also signed up to the TRIPS, or we became a members of World Trade Organization in 1995. What is TRIPS? Trade-related aspects of intellectual property. So till then, India was not a member of TRIPS, not a member of WTO, but in 1995, we have become a signatory. So when you become a signatory, you have to follow some rules, right? So TRIPS had said made some rules. According to that rule, we had to now allowing the patent applications for products. Initially, we did not have a product patent. Okay, so TRIPS have so many conditions, but TRIPS also gave some discretionary to the member states. It said that it's up to you if you want to file a patent application for medical treatment of humans or animals, you can. And it's not mandatory. Remaining all, it made mandatory. You have to have this rule. You have to have. TRIPS has told so many things that everything you have to do, you have to do it. But some conditions, like for plant protection, some conditions it gave a choice to the member country. So the first important country, it says that the member state may exclude. You don't have to give a patent for diagnostic, therapeutic, surgical methods for treatment of humans and animals. You don't have to give a patent protection. So why does it say? Basically, if you are doing something on the human body, it may not be industrially applicable, right? So these are the reasons why TRIPS said we are not compulsory. We are not forcing the member countries to file a patent application. You give a grant to the medical treatment, up to you. So this is one reason, because it may not be really falling under industrial applicability. And one more important thing is, if you have a patent and you can't, and if you enforce it again as a doctor, how he will practice, right? So doctors need to practice. So keeping these two in mind, TRIPS said that up to you, member country, up to you. If you want to have a patent application, it's fine. If you don't want, it's fine. It is only discretionary, not direct. Okay, so we became a member in 1995. So we amended the Patent Act in 1970, Patent Act of 1970. In 2005, we amended. Now we are allowing product patents. Okay, as Mr. Vijay Kumar already told. So we have some section 3, which defines clearly which are not patentable. So your medical device may fall under these 3 conditions. So be careful. Section 3F, Section 3I, and Section 3K. Okay, so he was saying, right? So Vijay Kumar is telling us it's not necessary that you have to go to a patent agent or patent attorney. You can draft, but these claims this patent application is called techno-legal document. You are good at technology, right? You may not be very good at legal. So that's where you need a patent agent. So patent application is basically a techno-legal document. So what is Section 3F? He already mentioned to you, right? If mere rearrangement. So you want to take water from a well in the night. So you take a bucket, you attach a torch, and you take water from the well. So you have torch, you have a bucket combined. Is it patentable? No. Why is it not patentable? I know torch, I know bucket, right? You just can't just add them and get a patent out of it. So be careful. If you have a medical device, you have to overcome Section 3F. How do we overcome that? You have to show them it's not a workshop improvement. I'm not just adding one tool, one screw, one thing. I'm doing much more. My invention is doing much more. You have to show that. And it's not a combination of known devices. And it is very better. It is a better and cheaper alternative. I think just we heard from him. Mr. Vijay Kumar explained all these things. Then we have Section 3I. Section 3I clearly says medicinal, surgical, curative, prophylactic, diagnostic, therapeutic treatment of human beings are not patentable, right? So be careful. When you draft a claim, you should be extremely careful. So suppose you say a method of treating condition X by administering a composition. If you say that, it's not patentable because why? Your claim is reading a method of treating. So it's not patentable. Now the patent attorney will rewrite the same claim, how he writes, a composition comprising Y or a pharmaceutically acceptable salt thereof for treatment of condition. So now what are you claiming here? You are claiming a composition. So it is patentable. So that's where you might need some help, some legal help to manipulate your words. It is your own invention. Basically, what did you invent? You invented a composition, right? But if we didn't know that, if you write a method of treating a cancer by administering this, then it is not, because it's a method of treatment. So be very careful while drafting your claims because it may fall under Section 3. Then we have something called Section 3K, right? Section 3K is basically computer programs per se are not patentable. In India, computer programs are patentable under copyright. So if you just show as a computer program, for example, I'm running a CT scanner and I have an app, I can see everything on my computer. I can see everything on my results. I'm measuring BP or I'm measuring some insulin, everything I'm measuring, and I attach to a mobile and I can see everything on my mobile. And if you draft your claim as if it is an app or it is a software, it's not patentable. It's not patentable under Section 3K. So we have to manipulate our conditions, our claims. Okay. Now, exactly opposite to India is US, right? So US is a member state, and it said that all medical treatment methods are patentable. Maybe that's the reason why most of the Indians are going and filing patent application in the US. Medical devices and methods of medical treatment are patentable in the US. Sorry, they don't differentiate the diagnostic and other methods of medical treatment, but you cannot enforce your patent against a medical practitioner, right? They made it very clear. Okay, if you have a patent application and a doctor is using your invention, you cannot go behind a doctor. Okay, but if a technician is he's just doing he's doing the diagnostics. He's not doing a treatment. He's only measuring some parameters using your invention. He is liable for infringement. So you can go behind him. So doctors are not infringers, whereas the technicians or other companies who are using your inventions are liable. Okay, so these are all covered under US. Pharmaceuticals, medical treatment methods, surgical procedure, everything is possible in the US to get a patent. So in US is comparatively liberal than India. So we have FDA has to, same how we have Drugs and Cosmetics Act in the US, they have a FDA. FDA has to approve, it has to go through FDA approval for a market to be released. So what happens is FDA, again, as usual, any government agency, either in India or US, it takes a lot of time, right? So FDA approval may take a lot of time. So what they have done is, if your patent is ready, patent has only 20 years life, right? After 20 years, anyone can practice. So to bridge the gap, so I am a patentee, my patent application is granted, but I can't practice because FDA has not yet approved. So I'm losing my time, right? So then they have said something called as Hatch-Waxman Act. Now let's not worry about much. Basically, they gave relief to the patentee to increase the patent term. Okay, so now the last slide. One simple slide is good enough to explain Europe. Europe and India are exactly same. In the Europe, you cannot have a medical treatment, method of treatment, patents are not accessible. Only US is different. So India, US is almost the same, and US is very different. Okay, right? Again, here, how do you manipulate? An apparatus claim to the medical device? Yes. A method claim to the process of manufacturing the medical device? Yes, you can patent it. A method or use claim of the operation of the medical device? Yes. Computer program that is linked to the method of manufacturing or operating the medical device? Patentable. But again, if you say anything about treating, method of treatment, or method of doing some analysis, something like that on the human body or animal, it's not patentable. So that's where you have to be very careful while drafting your claims. Thank you very much for giving me an opportunity. I don't know, I may exceeded time, I'm very sorry. So anything you have, any questions, I'm open to the questions.
Thank you so much, ma'am. It was a great session. Now I would like to invite Ms. Bhavna Mittal, the Program Manager, IPFC, ASSOCHAM, New Delhi. She's a qualified DST Women Scientist C Fellowship Program under Kiran IPR Division. And prior joining ASSOCHAM, she served with BIRAC, responsible for patent search and analysis of the research proposals submitted for funding support to BIRAC. She has a master's degree in pharmacy from Punjab University, Patiala, with more than 9 years of experience in academics and R&D. Ma'am, we request you to kindly take over.
Thank you so much, Kirti. Thank you so much for the warm welcome. First of all, I would like to thank Baba Farid University of Health Sciences and Dr. Bansal so that they have given us the opportunity to hold a session with their student and faculty members to interact with them. And secondly, I would like to thank my co-panelists, Mr. Vijay Kumar Shivpuje and Dr. Ramani, who have given a great session on the technical knowledge of IP related matters. So my presentation will be related to some other different activities. Let me share my screen. Is it visible?
Yes, ma'am, it's visible.
Full screen?
Yes, ma'am, it's visible.
So today's session, you all must be thinking, what is this ASSOCHAM IP Bootcamp? So we are going to have this master class with Baba Farid University of Health Sciences, Faridkot. But let me tell you brief about our initiative, ASSOCHAM IP Bootcamp. Like we have bootcamp for the mountaineering and all. So we are here to bootstrap you for your inventions related to all the intellect you are having related to medical devices, dental apparatus, everything you can go for inventions. So this bootcamp is initiative of ASSOCHAM IPFC. It is being organized and it provides an opportunity to innovators to resolve all their queries related to intellectual properties in one-on-one mentoring session with IP experts. You must have thought of, you all the students must have thought of that, oh, I can invent this one, I can invent that one, but you may not be having that much of expertise with you that can I go for that or can I go for this? So you can consult to us. This bootcamp is free of cost. We will not charge anything, like we are not charging anything for the master classes. This is a completely free of cost initiative just to make our younger generation, our innovators, our scientific fraternity, to make them aware of their IP rights and to bootstrap them so that they can pursue their inventions and commercialize them. IP Bootcamp will provide counseling as well as advisory for IP identification, protection, and strategic use in day-to-day business to achieve business excellence and competitive advantage. So intellectual property, like already Vijay sir has told, that it refers to the creation of minds such as inventions, literary and artistic work. Literary artistic work, we used to have a copyright on that. Designs and symbol designs, we can register as an industrial design. Symbols, names and images we can use as trademarks. So, who can apply for this ASSOCHAM IP Bootcamp? Any individual innovators like you people can also come to us for this IP Bootcamp services. Now, any startup, any MSME, any budding entrepreneur, any academia, researcher, scientist, professors, students, they can come to us, they can consult to us, they can strategize their IP policy or IP protection, how they want to pursue it. They can discuss everything with us. We'll sign a non-confidential agreement, and we all will be a party. So your information will be confidential with us. There will not be any disclosure out of that. You can pursue or not, that is your wish, but you can consult to us at any time. Bootcamp is pro bono or free of cost. So the domains we are serving for the bootcamp are life sciences, healthcare, diagnostics, medical devices, drugs, vaccines, drug formulations, delivery systems, industrial biotechnology, medical biotechnology, nanobiotechnology, herbal research, agriculture, pesticides, everything which is related to life sciences, health sciences, pharma, medical sciences, everything you can come to us. How to get admitted for this bootcamp? The registration is required. We are having a team of our IP experts. You can send an email to us and you can register for IP bootcamp. We will select 5 out of them, and we used to give half of an hour to every registrant. After every 15 days, we used to conduct this ASSOCHAM IP bootcamp. So what are the gains? The gains out of this ASSOCHAM IP bootcamps is to identify and protect your IP assets. Like Vijay sir was telling, and our Dr. Praveen Bansal has already told that medical students generally consider that they cannot go for inventions because the medical there are some complicated, there are some Section 3 implications related to medical devices or diagnostic or treatment related to human diseases, etc. So that is not the case. Like Dr. Ramani was already speaking before me, that all is your manipulation of the words, or you can manipulate your claims, and you can protect your invention from falling into that Section 3 implications. So that is how you can consult to us, and we can tell you that how you can identify and protect your IP assets. One-on-one interaction with IP experts, that is how you will be dealt in this ASSOCHAM IP bootcamp. Then you can strategize for IP filing and IP protection with the limited budget and resources. We can guide you for that. How can you go for the IP protection for all your IP protection? Like if you want to file a design, industrial design, and you want to file a patent also, and then you want to commercialize your product out of it, so you want to register a trademark also. So all these we can strategize for you, that with the limited budget you can start with one, and then you can go for another and go for another. Any other query related to IP, if you are having, you can consult to us. Now, coming down to the objectives of the ASSOCHAM, we used to provide strategic policy and advocacy to all the stakeholders. We used to increase the awareness about the role of intellectual property in today's knowledge-driven economy. We used to provide services such as IP protection, counseling, and advisory service to all the stakeholders. We used to handhold MSME for identifying their intellectual property in their day-to-day business and leverage it for their business excellence. We used to provide MSME the strategic management of their technology as well as their IPR. We used to enable MSME from the states in understanding, identifying, and use of their intellectual property right for building competitive advantage. So what are the facilities we used to provide? Like we are having a ASSOCHAM IPFC, Intellectual Property Facilitation Center. We used to provide these services. IP awareness, like we are doing right now, we can customize the sessions according to the need of the audience or need of the university or institute. Then we used to do IP analytics, like prior art search, novelty, patentability search. All these we used to do. IPR registration and prosecution, we used to file the patent application, we used to register copyright, trademark, and geographical indication, everything. We used to provide policy and strategy. If as Dr. Bansal has already told, that they are having a IPR cell in the university. So if someone is there to contact us for making the IPR policy for their institute, we can guide them for that too. Then coming down to the IPR commercialization, if you are having any product, we are an industry body and we are having a huge database of MSME related to inventions also. So we can help you for your IPR commercialization too. Next, capacity building and IP pre-diagnosis, and we can manage your IP portfolio too. Then these are our service sectors. We used to provide IPFC services to the MSME, startups, incubation centers, individual innovators, as well as university setups. Now coming down to one of our important initiative, L2 Pro. L2 Pro is learn to protect, secure, and maximize your innovations. This is an initiative which is DPIIT promoted. It is it is an IP e-learning platform which is being launched by DPIIT on October 14, 2019. Basically, this is an IP portal to educate Indian startup, micro, small, medium enterprises, as well as the innovators sorry, uh, as well as the innovators on their fundamentals of intellectual property rights. So this is the IP e-learning solution where you get all the information. Even right now we have provided to you. You will be having all these information in detail on one click away from you, and free of cost at your desktop level or your mobile handy. L2 Pro is a IP e-learning solution launched by DPIIT, Qualcomm, and NLU Delhi. So it is a collaborative project. So L2 Pro is a IP learning platform which is having 11 modules which are based on the level of knowledge, as well as this distributed into 3 levels: basic level, intermediate level, advanced level. So basic level consists of all the general introduction, patents, trademarks, geographical indications, copyrights and neighboring rights, industrial designs protection, unfair competition, trade secrets, plant variety. All the basic intellectual property rights are covered into the basic level of L2 Pro IP learning portal. Then coming down to the intermediate level, how you will apply this knowledge to while you want to attain a IP right. So then intermediate level comes in filing and acquisition of IP, how to do IP searches, and freedom to operate. FTO is freedom to operate searches, assignment and licensing agreement. If you are having an invention and you have filed a patent, you have filed for a patent and you get a patent granted within your hand. So you are not having that much funds that you can manufacture some medical device or any drug, but you want to make money out of it. So you can go for license agreements. You can give a license to someone else who will manufacture on behalf of you, and you can have a mutual agreement so that you will also generate some revenue out of that, and they will also generate some revenue out of that. They will pay you for the using that invention. So next, coming down to the advanced level. Advanced level means you want to make money out of it, and you want to handle the dispute out of that. So access to funding and venture capital and IP, introduction to standards and standard setting organization is all in the advanced level. Then dealing with disputes means someone has infringed your rights and you have filed a dispute for that. and you want to defend your for your intellectual property, right? So all this is covered in advanced level: infringement, validity, and defenses, arbitration. Next, what this is actually, each module comprises of e-text for understanding the concepts, and there are some short animated videos of the concept for the detailed learning, and there are links to the additional resources on the subject. Like we want to know the what is the fees for patent filing for any individual, for any startup, for a university. So all these are additional resources that you can click a link over there, and you will be on the page of IP India website. So where you can get all the details, latest details, any amendments, any things which are modified from the time of it that it was launched. You will get to know all the amendments also. Next is it is consisting of quiz and case studies for assessment. Like intellectual property rights, it is not the case that you have read everything on the theoretical basis and you are attempting some questions. So you will be having case studies. Like if you are having your own painting and someone is also drawing the same painting, will you be having copyright on that, or that will be having a copyright on that, or you will be infringing someone else? That kind of case studies related to patentable subject matters, related to all the subject IPRs. So the learners will be having the joint e-certificate by SIPM, NLU Delhi, Qualcomm, after successfully completing the e-learning module. Now I want to tell you about one thing here, that whosoever will be the fastest completing the advanced level of L2 Pro IP learning platform from your university, Baba Farid University of Health Sciences, they will get a they will be recognized by our L2 Pro social media handles. Will showcase you on your certificate, and your short video or your quotations will be shared from the our L2 Pro social media handles. Kindly use the L2 Pro IP learning platform. So we used to organize a lot of webinar on this L2 Pro program. Recently, we have scheduled one webinar on 1st of September, which was on IP funding opportunities. So next we will hold in the month of September itself, within the last week. So urge all of you to attend the webinar. Now, next, how to sign in. See, I have given some examples. Like I am having my email ID registered with L2 Pro. So if you have saved your credentials in the computer itself, so you will be having the option of sign in only. Your username, password will come automatically, and you get signed into the IP portal. But if you are a new user, then you have to register for the portal and sign up. These all are the details which are mandatory to join this IP learning platform. So I have filled one, created one another email ID for that. And these are my all details. I have filled in details. Then I agreed to the terms of conditions, sign up. Then you will be, there will be a message popped up on, you have registered successfully. An email is sent to you from L2 Pro India. You need to follow the instructions in the email to verify and activate your account. Mind it, please read the instructions. And then yesterday also I was having some queries from someone that they were not able to log in. Only when you will sign in from here and you will go to your email, you will verify your email, only then you will be able to register, and then you will be your account will be activated. So this kind of verification of email ID comes into your inbox, that L2 Pro India support email is there, and you have to click here. Click here to verify email. When you will click here, then you will be a registered user. Your account has been activated successfully. Sign in. Okay. So this kind of courses you will be having: basic course, intermediate course, advanced course. Then this is the some screenshots from the IP portal itself, like introductory video. So all this information you must be gaining in this webinar. You will all be having on your desktop itself. introductory video. A patent granted in India is valid only in India. This is a kind of brain teaser. Like, you are aware of your IP rights now. Tell us what is the IP right here and what cannot be. So next is the types of IPR. Like, all the types of IPRs are listed here. You get all the information in this portal, industrial design patent, everything you are aware of right now. So this is the patent procedure in India. Dr. Ramani are telling us about all these details, that how we can file a patent in India, how we can file a patent in abroad. So all this information you can get here into the L2 Pro IP learning portal itself. So this is the international filing timelines, PCT. So this is the outsourced information. This slide I specifically put in just to make sure you, all of you, that the outsourced information is always here. The patent fee, you can click here. All the information you will get from the IP India website. Patent facilitators who are there to facilitate you for patent filing free of cost. Trademark facilitator from Government of India, they have provided. SIPP scheme, what is it? How can you find the details? All these are here in this. This is a summary video. These are the pictures from page 38 of 38, means all the lesson you have completed, then there will be a summary video. So it will summarize all the chapter, all the lesson related to one of the intellectual property right. And then you will be having a module assessment. Module assessment means this, like here, basic module assessment. You have read all these 4 chapters. Now your knowledge will be assessed by the set of 30 questions. If you will score more than 60%, you will be passed. And then see here it's 83%. So then there will be a link generated here, download certificate. Then you can download the certificate from here itself. This kind of certificate you will get. Like, the certificate is DPIIT, SciPAM, Qualcomm, NLU Delhi, CIIPFC. So this kind of certificate you will get, and whosoever will be having the fastest who will be generating the fast certificate in the fastest space, so they will be showcased on our social media handles on of L2 Pro. So this is our team for ASSOCHAM IP Bootcamp. You can connect to us, any of us. You can connect to us, and you can get the knowledge about your IP rights, or how you want to go for your filing for your IP rights. Thank you so much. With this, I conclude my session here. Over to you, Kirti.
Thank you so much, ma'am. I'm sure with this presentation, the interface of L2 Pro and the entire registration procedure is clear to the audience. Now, I see a question in the chat box. In the nursing field, if we are developing any tool for assessment of students or patients, can it be patented? I request Dr. Ramani, ma'am, to kindly take this question.
I mean, again, how it's just an app, it's just a tool, or what exactly it goes. If it's just an app and it's only computer program kind of stuff, it's not patentable in India. You tie it up with some, you show some technical effect, you add, show some instrument which is associated with it, yes, it's patentable. So that's what, computer programs per se are not patentable under section 3K. They can be copyrighted. But you have a tool, and that is attached to a machine which is novel, new, and industrial applicability is there already. So if we can show it is not obvious, then we can file a patent application. Tool,
Thank you.
software per se is not patentable.
Thank you so much, ma'am. I hope it answers your question. With this, I would like to conclude the session. Thank you so much, Baba Farid University of Health Sciences, for giving us this opportunity to create this awareness program about intellectual property rights. All the esteemed panelists, Dr. Ramani ma'am, thank you so much for sparing a lot of time and enlightening us with the patent filing procedures and the various forms available and how to do the patent filing. Mr. Vijay Kumar Shivpuje sir, I thank all the panelists, and I hope all the students and the attendees will make use of our initiatives and make the best out of it. Thank you so much.
Thank you all.
Thank you.
Thank you, ma'am. Thank you. Ma'am.
Thank you very much. Thank you.
Sir.
Thank you.
Much. Thank you.
Thank you, Abnaman.
Thank you. Thank you so much.